Good evening. Today is Tuesday, April 20th, 2021. The Standing Committee on Agriculture and Food will begin at approximately 6 p.m. with the chair to be announced. Thanks and have a good night.
Good evening. Will the Standing Committee on Agriculture and Food please come to order? Our first item of business is the election of a chairperson. Are there any nominations? Mr. Peterson?
I nominate Mr. Smook.
Mr. Smook has been nominated. Are there any other nominations? Hearing no other nominations, Mr. Smook, will you please take the chair?
Our next item of business is the election of a vice chairperson. Are there any nominations? The Honourable Mr. Peterson?
I nominate Mr. Michalewski, please.
Mr. Michalewski has been nominated. Are there any other nominations? Hearing no other nominations, Mr. Michalewski is elected vice chairperson. This meeting has been called to consider the following bills. Bill number 36, the Public Health Amendment Act, Food Safety and Other Amendments. Bill number 62, the Animal Diseases Amendment Act. I would like to inform all in attendance of the provisions in our rules regarding the hour of adjournment. A standing committee meeting to consider a bill must not sit past midnight to hear public presentations or to consider clause by clause of a bill except by unanimous consent of the committee. If necessary, the Government House Leader will call an additional meeting of the Standing Committee on Agriculture and Food to complete the business before it. Written submissions from the following people have been received and distributed to committee members. Brandy Vizina, private citizen. Ashok Dasgupta, private citizen. Christy Carroll, private citizen. Michael Pout, private citizen. Ann Walker, private citizen. Eugene Zach, private citizen. Danny Tong, private citizen. Bonnie Brandt, private citizen. Ashley Chihonik, private citizen. Robert Dreger, private citizen. Larry Palmquist, private citizen. Julie Lafreniere, private citizen. Victoria Caldwell, private citizen. Sharon Lee Block, private citizen. Scott Tinney, Canadian Coalition for Farm Animals. Does the committee agree to have these documents appear in the Hansard transcript of this meeting?
Agreed.
Agreed, and so ordered. Public presentations guideline. Prior to proceeding with public presentations, I would like to advise members of the public regarding the process for speaking in committee. In accordance with our rules, a time limit of 10 minutes has been allotted for presentations, with another 5 minutes allowed for questions from committee members. If a presenter is not present when their name is called, they will be dropped to the bottom of the list. If the presenter is not in attendance when their name is called a second time, they will be removed from the presenters list. The proceedings of our meetings are recorded in order to provide a verbatim transcript. Each time someone wishes to speak, whether it be an MLA or a presenter, I first have to say that person's name. This is the signal for the Hansard recorder to turn the mics on and off. Also, if any presenter has written materials for distribution to the committee, please send the file by email to the moderator who will distribute it to all committee members. Thank you for your patience. We will now proceed with public presentations. We have a presenter this evening who wishes to speak in French, Stephanie Allard. Our usual practice is to allow presenters speaking in French to go first. Is this the will of the committee to allow Stephanie Allard to present first? Agreed, and so ordered. We have another request from presenter Jody Lazar, who joins us from Nova Scotia. She has requested that she be allowed to present near the beginning of the meeting, as she is a few hours ahead of us. Is it the will of the committee to allow Jody Lazar to present next after Stephanie Allard? Agreed, and so ordered. I will now call on Stephanie Allard and ask the moderator to invite them into the meeting. Please unmute yourself and turn your video on.
Bonjour. Je m'appelle Stéphanie Allard.
Ms. Allard, could you please turn your video on?
Oh. Bonjour, je m'appelle Stéphanie Allard et je me présente
Ms.
comme
Allard, you
citoyenne,
may proceed with your presentation.
citoyenne indépendante de Winnipeg, Manitoba. Et puis, je veux vous parler ce soir. Je veux prendre la parole au sujet du projet de loi 62, qui est un projet de loi sur le bâillon agricole ou ag-gag. Je m'oppose à cette dangereuse loi qui est de type ag-gag pour silencer les citoyens. Car l'objectif de la loi porte sur les maladies animales pour prévenir les épidémies dans les exploitations agricoles. Cependant, cette loi va bien au-delà de cet objectif en empêchant les gens de documenter la souffrance des animaux dans les camions de transport et en refroidissant la défense des animaux. Une loi de bâillon agricole est conçue pour rendre illégal le fait les citoyens concernés de documenter et de dénoncer les conditions dans les fermes, les abattoirs et les camions transportant les animaux. Certaines de ces lois érigent en infraction le fait de pénétrer dans une installation agricole sous de faux prétextes, rendant ainsi illégale la réalisation d'enquêtes sous couverture dans ces installations. En raison du potentiel du projet de loi de restreindre les activités de protestation pacifistes et d'avoir un impact sur les droits des individus à la liberté d'expression, il y a même jusqu'à 10 professeurs qui ont averti que cette loi viole probablement la Charte canadienne des droits et des libertés. Des pratiques cruelles, y compris la macération de poussins vivants, la détention de porcs gravides dans des caisses de gestation si petites qu'ils ne peuvent même pas se retourner, et la détention de poules pondeuses dans de minuscules cages en batterie si petites qu'elles ne peuvent pas se déplacer ou déployer leurs ailes. C'est cruel et c'est inacceptable. Je vais aussi vous dire que il n'y a pas longtemps, je conduisais sur l'autoroute en revenant du chalet et puis je conduisais juste en arrière d'un camion transportant des dindos. C'était juste avant Noël, la température était gelante dehors, donc je crois qu'il faisait comme moins 30 ou quelque chose. Et ces cages étaient ouvertes. J'avais des larmes aux yeux. C'était déployable de voir ces dindons dans ces conditions. Je crois qu'on devrait faire plus pour protéger les animaux. Je vais aussi vous laisser savoir que j'ai vécu en Corée du Sud pendant plus de 2 ans. Et je fréquentais un café Internet et juste à côté, on voyait une ferme qui élevait d'élevage de chiens. Donc, ils élevaient ces chiens pour de la nourriture et C'était déployable, la façon dont ils étaient et les conditions où ils étaient traités. C'est la même chose dans différents pays. Ils ont, pour nous, nos animaux domestiques comme les chiens, les chats, etc., on penserait, on laisserait jamais ces conditions être appliquées à nos chiens, nos chats. Mais dans des différents pays autour du monde, les chiens, c'est la même chose que les porcs ou que les poulets. Aussi, on a démontré très clairement que les animaux, c'est des êtres vivants, c'est des êtres qui ont des émotions, ils sont capables de démontrer de l'amour, de la peur, d'être contents, être excités, être fâchés. Ils ont toute une gamme d'émotions. J'ai beaucoup d'empathie pour les gens qui veulent protéger ces animaux. Les Manitobains, y inclus les Franco-Manitobains comme moi-même, on se soucie beaucoup de la protection des animaux, y compris les animaux élevés et abattus pour l'alimentation. Les animaux peuvent être transportés pour plus de 24 heures sans être donnés de l'eau, de la nourriture ou avoir de repos. Donc, je crois que les conditions qui sont allouées en ce moment ne sont pas bien, ne sont pas constitutionnellement bons pour une société qui se dit évoluer. Les personnes qui participent à des manifestations paisibles devant les abattoirs documentent régulièrement les conditions épouvantables qui règnent à l'intérieur des camions transportant les animaux vers l'abattoir, notamment les blessures sanglantes des animaux souffrant d'épuisement dû à des conditions incroyables comme le froid extrême ou la chaleur extrême, tout entassés l'un par-dessus l'autre. Je l'ai vu moi-même. Et je crois que la plupart des gens, si on voyait ces conditions, je crois qu'on voudrait avoir des lois qui sont plus strictes et c'est très important d'être transparent. Donc, la transparence, c'est important pour qu'on ait une société qui respecte les lois et de la Charte canadienne des lois et des libertés. Donc, merci beaucoup. C'est ce que j'avais à dire et bonne soirée.
Thank you for your presentation, Ms. Allard. The Honorable Mr. Peterson.
Thank you, Mr. Chair, and thank you, Ms. Allard, for your presentation. Certainly heard what you have to say, Mr. Chairman. I have no questions for her.
Are there any other questions? Mr. Brar? Mr. Brar?
Thank you, Ms. Allard. I really appreciate you taking time to share your thoughts with us. Just wondering, how do you look at the role of education and training for the general citizens and the producers to handle this situation in this society?
Ms. Allard, did you have any response to?
Je crois que pour moi, je vois la loi qui est plus stricte, donc en respectant la vie des êtres vivants qu'on élève pour la consommation. Je crois que c'est très important d'avoir des règlements qui sont extrêmement stricts pour que la souffrance et leur vie soient respectées. Je crois que c'est important qu'on éduque la population en fait, la consommation, c'est documenté, c'est des faits scientifiques que la consommation de la viande, en fait, ça nuit à notre santé physique. Et donc, ce serait important que si nous voulons, je comprends qu'il y a des fermiers, il y a des fermes, il y a des opérations, ça fait partie de notre économie, mais on peut élever le coût de la viande pour augmenter le niveau de règlement et pour faire certain qu'on fait ça d'une façon éthique et d'une façon qui est bien pour tout le monde, notre santé et la santé des animaux.
Are there any further questions from the committee members?
Yes.
The Honorable Mr. Gerard.
Merci pour votre présentation, Madame Allard. Je vous demande, vous avez dit que cet projet de loi, c'est contre la Constitution et c'est à cause qu'il est contre le droit de l'Assemblée, la liberté de réunion. Est-ce que c'est pour sa raison?
Ms. Allard, do you have a response?
Ça c'est une des raisons pour le rassemblement. Et aussi, il y a eu des citoyens concernés qui se souciaient du bien-être. Les animaux qui souffraient, ils étaient presque à mort. C'est documenté que même avec... je crois que c'est 2 millions d'animaux qui se font tuer juste en se faisant transporter jusqu'à l'abattoir. Et aussi, c'était pour dire que les personnes qui ont du souci pour les animaux peuvent donner de l'eau, de la nourriture à ces animaux qui sont souffrants, que ça ne devrait pas être illégal, qu'il ne devrait pas avoir une infraction de 10 000 $ et puis de 1 an de peine en prison, qui est contraire à les lois qui met seulement les gens qui font mal aux animaux de toute cruauté jusqu'à seulement 6 mois de prison. Donc, c'est pas comparable. Il y a des gens qui donnent de l'eau, donnent de la nourriture.
Miss Allard, your time has expired.
Qui ont des peines qui sont
Miss Allard,
beaucoup plus
your
graves
time
que les gens qui font
for question
beaucoup de
has
mal.
expired.
Juste incroyablement la cruauté comme insensée à ces animaux. Donc, ça, c'est le deuxième ou troisième point.
Time for questions has expired. We thank you for your presentation. We will now move on to our next presenter. We will move on to Jody Lazar. I will now call on Jody Lazar and ask the moderator to invite them into the meeting. Please unmute yourself and turn your video on. Jody?
Yes, hi, can you see me?
Yeah, Jody Lazar, please proceed with your presentation when you are ready.
Okay, thank you. My name is Dr. Jody Lazar. I am an assistant professor at the Schulich School of Law at Dalhousie in Halifax. And I'm here today to share with you my expertise in Canadian constitutional law, which I have been teaching at Dalhousie since 2014. I've also been teaching a seminar since 2017 called Animals and the Law. And I have also been doing research funded by the Social Sciences and Humanities Council of Canada on the constitutional dimensions of animal rights activism, the question of constitutionally protected speech, and the impacts of this kind of legislation across Canada. I'm here specifically, quite frankly, because I'm concerned, as we've just heard, that Manitoba might be on the verge of adopting an unconstitutional law. I recently signed a letter to this effect, and I want to use my time here to flesh out some of my concerns. I'm going to focus on two specific provisions of the proposed bill, both related to transport. And I will start with section 13.2 sub 1 and the prohibition on interfering with a vehicle transporting animals. It's quite clear, of course, who this is targeting: animal rights activists who gather outside of slaughterhouses and carry out what they call vigils by bearing witness to farmed animals during the last moments of their lives. So this looks to me like a direct restriction on the charter right, as we just heard, to assemble peacefully in public spaces. It is telling people that they cannot carry out these activities. Now, I understand that this kind of activity or this kind of protest, like many peaceful protests in public places, may be inconvenient, certainly. That is the objective, of course, of protest and dissent. But it is a right guaranteed by Section 2C of the Charter, and all limits on its exercise must be justified by the government. An interesting thing about freedom of peaceful assembly is that it has really not been the subject of much judicial interpretation, which is why I won't say much more about it. But I think the reason that there is so little relevant discussion in the case law is because the provision is clear. Everyone in Canada has the right to peacefully protest, and limits on that right have not, to my knowledge, been justified, at least not at the Supreme Court of Canada. I'll turn to the next provision, section 13.2 sub 2, and that's the prohibition on interfering or interacting with an animal in transport, which raises a couple of concerns for me. So first, it's not entirely clear what it means to interact with an animal. Is making eye contact interaction? What about taking photographs? Of course, the context is different, obviously, but when I think about having my photograph taken, I certainly consider that as involving some kind of interaction with the photographer. And if taking photos, a central part of bearing witness, if that is not interacting, what if the animal moves and makes contact with the lens or the phone or the hand of the person taking the picture? I think that's probably an interaction. And what about talking to the animals? Again, is that interaction? So I don't think the legislation is entirely clear on this, and that lack of clarity I think presents some rule of law issues. The rule of law is, of course, a central feature of our constitutional democracy, and it requires that laws be public and knowable, that people know in advance what they are allowed and not allowed to do. And I'm not sure that this law fulfills that requirement. Definitions aside, I think that this provision might also conflict with of course, again, the right to peaceful assembly, but also I would argue that it limits freedom of expression. People who protest outside of slaughterhouses, who approach transport trucks with animals on them, are carrying out a particular expressive activity. As I mentioned, they are bearing witness to the final moments of animals' lives, attempting to bring them some kind of comfort, and documenting and sharing what they see with members of the public. And the law here tells them that they cannot do that they cannot express themselves in a particular way. The Supreme Court of Canada has explained that there are three reasons that the Constitution or the Charter protects freedom of expression. First, to promote the pursuit of truth. And Canadian legal scholars describe bearing witness and these activities as an exercise in truth-telling and information sharing. So bearing witness and these types of gatherings are about stimulating criticism of the food system and catalyzing change among consumers of animal products. And sure, producers and members of the industry understandably might disagree with that message, but people nevertheless have a right to share it, and consumers and the general public have a corresponding right to hear it. Second, bearing witness is also political speech. It aims, again, to spread awareness about the law and regulations dealing with animal agriculture in Canada, and specifically the federal regulations governing the transportation of farmed animals. I'm not going to get into the specifics of those regulations. We've heard a little bit already, and I suspect you'll hear more about that tonight. What I will say is that a former lead vet with the CFIA, which of course sets the maximum transport times, has come out clearly saying that Canada has the worst animal transport regulations amongst developed nations. Finally, the kind of advocacy targeted here prevents individuals from promoting individual self-fulfillment and human flourishing, which is the third purpose of freedom of expression. Many of the people involved in these activities see this as an expression of their deep-seated, strongly held ethical beliefs about the ways that we interact with animals in the context of animal agriculture. I'm about halfway through my time, so I'm just going to say one last thing about the limits themselves before I talk briefly about the government's burden of justification, and that's that this is political activism, truth-seeking, and information sharing. American courts have recognized that this is a proper subject for public debate. It's what I would characterize as high-value speech, which is a phrase I'm borrowing from the literature on freedom of expression in Canada about the Supreme Court saying on multiple occasions that political speech lies at the heart of freedom of expression. In practical terms, that means that restrictions on speech should be difficult, on this kind of speech, should be difficult for the government to justify. And that will be my final point. I'm sure that the members of the committee all know that examining legislation for compliance with the Charter is a two-step process. When challenging a law, an individual must first show that a right is limited, and I've taken you through my thinking on that. Next, the onus shifts to the government to show, using concrete evidence, that the limit is reasonable and demonstrably justified in a free and democratic society. Those are the words of Section 1 of the Charter. And my concern here is that, respectfully, these limits may not be justifiable, because to my knowledge, there is simply no evidence demonstrating any kind of connection between the activities of activists outside of slaughterhouses and the safety of farmed animals and the food system. People bearing witness to animals in transport do not give them food. And while they do sometimes give them water when they are in visible distress, there is still no evidence that that carries any kind of risk to animal safety, food safety, or biosecurity. In fact, as I'm sure many people here know, in one of the few judicial pronouncements on this kind of activity, an Ontario judge a few years ago rejected the suggestion that giving a thirsty pig on a truck water on a hot day posed any kind of risk at all to the animal or to the food system. The pig was offloaded and processed as usual, and the accused in that case was, of course, acquitted because giving water to a thirsty animal does not interfere with the legal use of that animal. Or, as her supporters would put it, because compassion is not a crime. And then finally, on a similar note, regarding that same absence of connection between activism and risks to biosecurity. Just last month, another Superior Court judge in Ontario rejected the argument that documenting video footage of farmed animals, in that case mink, had any effect at all on biosecurity, animal safety, or farmer safety. In that case, the objective of the accused was very similar to that of members of the SAVE movement, to publicize the condition of farmed animals. And he, like the accused in the pig trial, was acquitted because taking photos or videos did not result in any harm to anyone. So what this means in constitutional terms is that there is no rational connection under Section 1 of the Charter between prohibiting the constitutionally protected activities of activists on roads outside of slaughterhouses and the objective of protecting food safety. And that is enough, in my view, and according to my understandings, for the law to fail a charter challenge. I will stop here, and I'm happy to take questions. Thank you so much for your time.
Thank you for your presentation, Ms. Lazar. The floor is now open for questions. The Honourable Mr. Peterson.
Thank you, Ms. Lazar, for your presentation. Welcome to Nova Scotia. We're one of the few legislatures that actually have public hearings, so I'm glad to hear you were able to present here. And I have no questions, Mr. Chair.
Thank you. Do any other committee? The Honourable Mr. Brar.
Just wanted to say thank you, Jody, for your research and information that you shared with us. Really appreciate it. Thanks.
Thank you.
Ms. Lazar, did you have any response to Mr. Brar?
I'm glad that people are interested.
The Honourable Mr. Sala.
Thank you very much. Thank you so much, Dr. Lazar, for making time to present to the committee tonight. It's really great to hear your words and what you've shared. My question to you is, how do you fear a law like Bill 62 could possibly be abused, or how do you feel like what are the impacts of a bill like this once it's passed?
Ms. Lazar?
Yes. I mean, in terms of abuse, I think it's, even if a judge were to find parts of it constitutional, which I am skeptical about, it still has an extremely chilling effect on activism. We've seen the impacts in Ontario. You know, Ontario just adopted a very similar bill with very similar transportation provisions, although it's not as specific in terms of like food and water. But the result of that is that activists, members of the SAVE movement and groups like them, no longer feel comfortable carrying out their constitutionally protected right to gather and to express themselves freely. So, and, you know, that is of course at the grounds or at the heart of the, or one aspect of the constitutional challenge that has just been launched against the Ontario government. So, I mean, in terms of abuse, I would say sort of intimidation on the part of the authorities and a chilling effect on activism and political and democratic speech. In terms of impacts, the same, you know, not only does it chill speech, but it also prevents the public from seeing what a federal court judge has called, has characterized as part of the right to freedom of expression. In a recent case, a federal Court of Canada judge said that the right to make ethical choices about food consumption and the right to know about how your food is produced is protected by freedom of expression as well as freedom of conscience. So that is one impact, and it's a quite serious one if people are not are prohibited from learning about how their food is produced and how agricultural farmed animals are transported to slaughter throughout the country and in Manitoba, of course, as well.
Are there any further questions for Ms. Lazar?
Yes.
The Honourable Mr. Gerard.
Yeah, the right of freedom of assembly, does that include the right to impede or block the progress of the truck on its way to wherever it's going?
Ms. Lazar?
Yeah, sure. Like I said, there's very little judicial interpretation of Section 2C of the Charter, so I can't give you a judicial answer to that. What I can say is that that's what I understand kind of protest activities to be. You know, you picture large demonstrations and they're inconvenient, but the police and authorities, they all understand that Canadians have the right to do that kind of thing. And in many cases, they'll assist them or support them in doing that by blocking roads, by diverting traffic, you know, whatever it is. And there's really no other explanation for that kind of support on the part of law enforcement other than respect for constitutional rights.
Thank you.
Are there any further questions for Ms. Lazar? Seeing none, thank you for your presentation, and we will move on to the next presenter.
Thank you very much.
We will now move back to Bill number 36. There's a presenter from Bill 36. I will now call on Philip Veldhuis and ask the moderator to invite them into the meeting. Please unmute yourself and turn your video on. Mr. Veldhuis, can you hear us?
Yes, I can.
You may proceed with your presentation when you are ready.
Thank you very much, Mr. Chairman. So I'm speaking to Bill 36, and my name is Phil Veldhuis, and I'm president of Direct Farm Manitoba. Direct Farm Manitoba is the association of farms and farmers markets that sell directly to Manitoba consumers. Our association takes our marching orders from a report and a process initiated some years ago with a report ultimately written by Dr. Wayne Lees called Advancing the Small Scale Sector, and that has a number of recommendations pertinent to this bill. I'd like to speak first to Section 32, subsection 2, which denies the producer of a food product the opportunity to appeal should a food inspector have reasonable reason to believe that the food might present a hazard. And I certainly understand why the government doesn't want to be held the responsibility of holding that food in safe and certain conditions. And so it might at first seem reasonable to not have this a right to appeal for the return of the product. At the same time, this means that the producer doesn't have any legal mechanism to address perhaps disagreement about whether the concerns of the inspector were reasonable or not. And so we recommend to the committee that they consider at least the requirement that the inspector be required to preserve samples and evidence and have some mechanism by which a producer could follow up with the food inspection with Manitoba Health to find out if the opinion of the inspector could be upheld upon whether it be an informal appeal process or a legal appeal. This bill revision also, while in general, I think is steps forward for our producers who very much want the food system to be simple and manageable. One of the changes is recommending adding the word gathering to the sort of food establishments. And that would seem to include, I would think, on any reasonable interpretation, all harvest activities. And so that would, I would think, include all farms. And I think that the committee should consider whether that might be overreach. Are they prepared to inspect grain storage as and grain harvesting as matters under this bill? I recommend that you review that definition. I also want to bring your attention to some things that are perhaps not here that should be. The roles of Manitoba Agriculture and Manitoba Health continue to be confusing to our producers. The general understanding that Manitoba Ag is responsible for the inspection of farm-facing food production, and Manitoba Health is responsible for public-facing establishments is very confusing to a farm that is both. And I don't see the sorts of clarifications in this revision that would help with that. I also don't see clarifications on things like online sales, online collaboration of farms who might be participating in exempt status, how they are going to be regulated if they collaborate with online platforms or with a farmer's market that's operating online. We continue to advocate for scale-appropriate regulations. Our farms and our members tend to be smaller operations who do not have multiple operators on site at all time. I know on my own farm, a number of the food safety protocols that I'm required to follow require double signature processes. I'm a one-man show. And so, making sure that as we build into the future with these food regulations, that we allow for small operators to be compliant and without the large burden of compliance that is, quite frankly, a large-scaled operation can afford, but a small one cannot. Many of the existing food safety programs are designed for farms that are producing a very large amount of a very small number of products. And the kind of farm that our association represents tends to be a very diverse farm, reaching right into the marketplace with a broad spectrum of farm food products. And the kinds of food safety programs that are going to suit those farms cannot be based on segregation of one food product from another. You can't say the way to make this farm safe is to have only chicken and nothing else, or only vegetables and nothing else. These farms want to be diverse. And so I recommend that you consider in your deliberations the complexity of a small, diverse farm operation. As we work forward, the important aspects of much of this work will be through the regulations that are imposed under this bill, and I look forward to opportunities to consult with this committee and the Minister and Manitoba Health and Manitoba Agriculture as those regulations are further refined. Thank you very much for your attention today.
Thank you for your presentation, Mr. Veldhuis. Floor is now open for questions. The Honourable Mr. Peterson.
Thank you, Phil, for your presentation, and I know our department has been in contact with Direct Farm Manitoba, and also I have staff listening in on this tonight, so we will certainly take your perspectives into account and on further deliberation of the bill, and also in regulations we will be consulting with you also. So thank you again for your presentation.
Mr. Veldhuis, did you have a response?
No.
The Honourable Mr. Brar.
Thank you, Phil, for your presentation, and I just wanted to offer an applause for all the Direct Farm Manitoba members, because I understand how much hard did you work for Manitobans during the pandemic, for example, offering online ordering and stuff. So thank you for that, one and all the small producers in Manitoba. My question to you is, what are your top 2 asks from Government of Manitoba for improving food safety at farmers market in Manitoba?
Mr. Veldhuis?
Top 2. Thank you. The top 2 asks for improving food safety. We've repeatedly asked a number of governments over the years for farm fresh eggs to be at farmers markets, and that continues to be our #1 priority. So much so that I'm not sure I could even come up with a #2 offhand. There's farms in Manitoba that can sell an egg at their farm. They can sell it at your door, but they cannot sell it at a farmer's market. And so that seems to be a gap in the regulatory structure. It's the same egg in all 3 places, and other provinces allow this. And so that is access to eggs at farmers markets would mean more customers would attend more regularly and would improve access for all.
Are there any further questions? The Honourable Mr. Gerard.
Yeah, thanks so much, Phil. Just a point of clarification, when you're talking about the diverse approach of small farm operations, what you're talking about is primarily things which would be in regulation. Would there need to be any changes in the bill as it is to facilitate that?
Mr. Veldhuis?
I don't think that the bill needs to be revised to allow it, but it would be great to see the bill offer some guidance to the minister's opportunity. Like the minister is allowed to exempt or regulate as the minister's office sees fit. I don't know if it's standard practice for that bill to include guidance as to what would be considered appropriate, and if it were. That we would include, we want these diverse and smaller farms to have the regulatory guidance to be in writing somewhere.
Are there any further questions for Mr. Veldhuis? Seeing none, we thank you very much for your presentation, and we will now move on. That concludes our presenters for Bill number 36. We will now move on to Bill number 62, the Animal Diseases Amendment Act. I will now call on Miranda, Desa, and ask the moderator to invite them into the meeting. Please unmute yourself and turn your video on. Miranda?
Good evening.
Ms. Desa, you may proceed with your presentation.
Good evening. I'm Miranda Desa, Canadian Council for Last Chance for Animals, or LCA, a nonprofit organization dedicated to eliminating animal exploitation through education, whistleblowing, legislation, and media attention. LCA has been involved in a number of high-profile whistleblower exposés in Canada, which have led to numerous charges based on the treatment of animals and legislative change. In fact, just last month, an LCA animal cruelty complaint led to the conviction of a Canadian farm for failing to meet appropriate standards. Moving into the second year of this pandemic, as a society, I believe that we have learned some important lessons about the connection between how we treat animals and disease. As a result, it is now more important than ever that we focus on ensuring appropriate oversight and transparency is in place rather than restricting access to information about animal agriculture. I'm here today to discuss the importance of whistleblowing and the dangers of ag-gag legislation. Whistleblowers are an essential part of our legal system, regulating the treatment of animals, the sanitation of food, the environmental issues, and the treatment of workers. Whistleblowers put themselves on the line to make the world a better place that is safer for everyone. They are an essential source of information in animal agriculture, filling in gaps in regulatory regimes and keeping an eye out for key types of whistleblowers. I'm here to discuss and undercover journalists. And undercover journalists obtain often through working in agriculture. The tasks of their employment, they are required to meet the same standards as all other employees and follow biosecurity protocols. Whistleblowers, like those that work with LCA, work within the parameters of the law to monitor the treatment of animals in agriculture and ensure appropriate standards are being met. Rather than reducing biosecurity, employee whistleblowers and journalists have historically increased sanitation and animal welfare by bringing troubling conditions to light and being catalysts for change. Whistleblowers are an important source of information about animal agriculture and increase oversight and transparency into how our food system operates. Over the years, LCA has made many whistleblower complaints about conditions in animal agriculture. These complaints have led to charges based on animal welfare and sanitation issues, as well as farm improvements. LCA investigates the treatment of animals and follows the law in doing so. Whistleblower complaints like these serve as an important source of information for regulatory authorities who rely heavily on complaints to ensure appropriate farm animal welfare standards are being met. Just last month, an animal cruelty complaint by LCA, based on whistleblower evidence, led to the guilty plea of a Canadian fur farm for failing to meet prescribed standards of care. LCA's complaint into that farm shone a light on numerous troubling issues over and above the farm's conviction, led to a number of improvements on the farm. If you're interested in learning more about the important information that is revealed by whistleblower exposés, I would encourage you to visit lcanimal.org for more information. Decreasing the flow of information out of animal agriculture and placing restrictions on journalists and employee whistleblowers has no rational connection to improving biosecurity. Rather, such restrictions will remove important avenues for bringing unsanitary conditions, animal cruelty, and workplace safety issues to light. Bill 62, the Animal Disease Act, will make some significant changes to the Animal Diseases Act. It will amend the act, and you know this, but to create what it calls biosecurity zone areas with restricted access on farms and in slaughterhouses. And the act will require consent from the owner of any animals in these zones for access, or consent from the occupier of the zones if no animals are present to enter. Consent will also be required to interact or interfere with animals with these zones or in transport, as well as to interfere with any vehicles transporting commercial animals. Now, trespassing or breaking into farms, slaughterhouses, and transport trucks in Manitoba is already illegal. It is also already illegal to damage private property or to harm farm animals. And as a result, it's our position that these new restrictions are unnecessary to protect biosecurity. And you'll hear a lot from others today, I think, on that point as well. But at this point, precisely what's meant by biosecurity zone is unclear, as will be expanded on in the regulations. And what exactly is meant by interact or interfere is also unclear. Although the text of the bill tells us that it would be broad, as it would include things like providing water and food to animals. And again, what exactly is meant by consent is unclear, as it's not yet defined. But other similar legislation in Ontario and Alberta have included language invalidating consent, where it's been obtained on what those acts call false pretenses. I don't see that language yet, and I'm hopeful that it will remain that way. Requiring people, because false pretenses language requires people who intend to gather information to whistleblow about hygiene and safety, the treatment of animals, and environmental issues to get consent in advance to collect that information, with very limited exceptions. Requiring this kind of consent criminalizes whistleblower exposés into our food chain and severely punishes whistleblowers acting in society's best interest. Laws that restrict information out of agriculture are known as agriculture gag laws, more commonly called ag-gag laws. Ag-gag laws make it a crime to reveal the truth. They are a severe erosion in oversight and transparency and an unjustified intrusion on freedom of expression. Access to this kind of information allows for consumers to make informed choices. It holds producers accountable for the practices they follow and allows for whistleblowers to report troubling conditions to regulatory authorities. Restricting the access of journalists and employee whistleblowers and people would significantly limit the flow of information out of animal agriculture. Restricting access to this information moves away from safety, transparency, and accountability. And Manitobans want and deserve to know where their food comes from and how animals raised for food are treated. Ag-gag laws prevent whistleblowers and from revealing truthful information about unsanitary conditions, animal cruelty, and unsafe working conditions in animal agriculture. They're a threat to freedom of expression, as well as our health and well-being. Ag-gag laws prevent Canadians from being able to make informed decisions about the products they purchase and the businesses they support. They also prevent whistleblowers from being able to hold producers accountable when they violate laws that endanger our health and the well-being of animals in agriculture. With COVID outbreaks having occurred in meat processing plants and farms in Manitoba, oversight and transparency are more important than ever. There have been at least 2 large outbreaks, one at Excelder Poultry Plant and the other at Maple Leaf Brandon's pork facility. Limiting whistleblowing only increases the risk for more of this. It is disappointing at this time as we see governments across Canada moving to stop access to this kind of information instead of focusing on the pandemic and making sure appropriate oversight is in place. Concerned Canadians have a right to know what is happening on farms and in slaughterhouses because it can directly affect the health and safety of the public. It is disappointing to see ag-gag laws popping across Canada, copied from similar laws in the United States. This is happening long after many states have had their ag-gag laws overturned as violations of the Constitution. The current pandemic has shown us there is a strong connection between the sanitary treatment of animals and disease, and now is not the time to shut down whistleblowing in Manitoba. We need it now more than ever. Thank you for your time, and I'd be happy to answer any questions you may have.
Thank you for your presentation. The Honourable Mr. Peterson.
Thank you. Thank you, Miranda, for your presentation. Very thoughtful, and thank you. No questions, Mr. Chairman.
Thank you.
The Honourable Mr. Brar.
Thank you, Miranda. Thanks for the wonderful information you shared with all of us. While working with Last Chance for Animals, you must have gone through some situations or some incidences at the factory farms or family farms. So how do you see the complaints and the intensity of such incidences at factory farms versus family farms?
Ms. Desa.
Well, I think that we see a lot of problems with large-scale industrialized farms because of the scale of the operations and the number of animals that are in place. But we also see problems with small family farms as well. You know, some of these family farms have practices in place about how they treat animals. Some of these farms don't have practices in place and have less standards as well. So I don't think it's fair to draw a distinction between the small and the large farms, although the larger farms have greater potential given the number of animals in terms of a pandemic risk and in terms of those kinds of hazards. But all farms, they have potential issues, and it's important to have appropriate oversight and transparency into all of them.
Mr. Brar?
Thank you, Miranda. A follow-up question is, other than bringing a new legislation to address these issues in this industry, what options do you suggest to address these issues?
Well, I think it's...
Ms. Desa?
Thank you. I think it's important that legislation legislation allow for whistleblowing and to ensure that these brave individuals are not punished when they come forward about things that they see in the course of their employment or things that people see in other situations. Canada, unfortunately, already doesn't have very good laws to protect whistleblowers. Additionally, if we're looking to work on biosecurity, I would suggest looking also at standards of care in terms of ensuring legislation that sets out an actual standard that needs to be followed rather than legislation that has loopholes. It sets a standard, then puts in place exceptions in standards of care for accepted industries. So I would suggest that having more concrete legislation about the standards that ought to be followed would be helpful as well.
Are there any further questions? The Honourable Mr. Gerard.
Yeah, I'm curious. You mentioned the United States, that a number of laws have been thrown out. Would they be laws which would have similarities to this law? And can you give us a little more detail?
Well,
Ms. Desa.
Certainly. Some of the laws that have been thrown out have had some similarities in the sense that the laws dealt with restricting information out of animal agriculture and dealt with things that would affect whistleblowing, as well as, in terms of having the ability for people to report what they observe in terms of reporting it to authorities and spreading that among people. Because, in the US, you're looking at freedom of speech, and here we're looking at freedom of expression. But freedom of expression is premised on fundamental principles and values that promote the search for and the attainment of truth, participation in social and political decision-making, an opportunity for the individual self-fulfillment through expression. So in this case, things that prevent people from getting important information through whistleblowing or out of what's going on in animal agriculture, those are kinds of things that we view as a high-level protected speech, and similar kinds of things that, you know, interfering with them has been found to be problematic in the United States.
Thank you.
Thank you for your presentation. Are there any further questions for? Seeing no further questions, thank you for your presentations. Ms. Desa, we will now move on to the next presenter.
Thank you for your time.
I will now call on Ms. Caitlin Mitchell, Animal Justice, and ask the moderator to invite them into the meeting. Please unmute yourself and turn your video on. Ms. Mitchell, you may proceed with your presentation when you are ready.
Great. Thank you very much. And thank you very much for the opportunity to present this evening. My name is Caitlin Mitchell, and I am a lawyer with Animal Justice, Canada's only national not-for-profit organization focused on using the law to protect animals. Animal Justice is based in Toronto, but I live here in Winnipeg. Now, a group of animal protection organizations has provided more detailed written comments to you. And due to the committee's rules, Animal Justice did not sign onto those comments, but I do commend those comments to you. They set out in a little bit more detail some of the concerns with the bill. So in the interest of time, I will focus my comments tonight on two overarching concerns with the bill. First is the prohibition on interacting with farmed animals. And second is the prohibition on giving farmed animals food and water. And we're concerned about this bill because, as you've already heard tonight, it is an example of an ag-gag law. These originated in the United States, and in the past year and a half, we've begun to see them cropping up in Canada as well. These laws are aimed in whole or in part at preventing individuals from observing, documenting, and publicly exposing the conditions in which farmed animals are raised, transported, or slaughtered. So as mentioned, the first overarching concern that I would like to discuss is that Bill 62 would create a new and incredibly broad offense of interacting with farmed animals. I'll focus my comments on section 13.2 sub 2, which applies to animals in transport, but 13.1 sub 3, which applies to animals in a biosecurity zone, is also troubling. Section 13.2 sub 2 is virtually identical to section 6.2 of Ontario's recently enacted ag-gag law. And in fact, it appears much broader, in fact, than Ontario's law. So like Ontario, it appears to be targeted at individuals who engage in peaceful protest activities on public property near slaughterhouses. It will capture a vast array of harmless activities, and without definition, it's hard to really even conceive of what it means to interact with an animal in transport. Does it include speaking to animals, making eye contact? What if you take their photograph? What if they nudge you or otherwise come into contact with you when you're near the truck? Professor Jody Lazar has already presented this evening on the potential unconstitutionality of Bill 62. I agree with her analysis and her conclusions, but rather than echoing her presentation, I will instead focus on the broader legal context in which Bill 62 is being introduced. Canada has some of the worst animal transport standards in the industrialized world. Cows and sheep can be legally transported up to 36 hours without food, water, or rest. Horses and pigs can be legally transported up to 28 hours without food, water, or rest. Animals are transported year-round during our extremely cold Manitoba winters and on balmy summer days. Canadian Food Inspection Agency, or CFIA data, shows that at federally inspected slaughterhouses alone, more than 1 million animals arrive dead each year, having died during transport. Nearly 9 million more are classified as condemned, meaning that due to conditions discovered before or after they're slaughtered, they cannot be consumed by humans. The reasons for an animal being classified this way would include bruising, frostbite, emaciation, and other conditions. So again, this data includes only federally regulated slaughterhouses. It does not include provincial slaughterhouses. So the numbers of animals dying in transport are actually much larger. Individuals protesting on public property near transport trucks raise awareness about these cruel conditions. And at times, these individuals are able to observe and document conditions inside trucks. As a lawyer, I am often contacted by individuals who have gathered footage showing conduct that appears to violate federal transport standards. I'm then able to use this footage and information to submit law enforcement complaints to the CFIA and provincial enforcement agencies. The footage that I'm forwarded, frankly, is often heartbreaking. It has included pigs dead in sweltering vehicles, while the are foaming at the mouth and in clear distress. Animals bleeding from open wounds, with caught in crates in clear distress as they struggle to free themselves, and feather bare chickens with bright red skin exposed to freezing temperatures. Because the vast majority of animals raised and slaughtered for food spend their lives indoors on private property, it's only during transport that members of the public can generally see the animals and observe their treatment. Now, I want to be clear that prohibiting individuals from interacting with farmed animals and restricting peaceful protest activities outside of slaughterhouses does nothing to protect biosecurity. Animal Justice has reviewed CFIA records related to biosecurity incidents and disease outbreaks at Canadian farms going back nearly 20 years. This data shows not a single disease outbreak or biosecurity breach linked to the activities of animal protection advocates or protesters. All of the incidents were caused by farm owners and operators themselves, and they were caused by things like shared needles or equipment, workers entering multiple facilities, feeding animals other animals, as in the case of mad cow, back and forth between animals and workers, as Manitoba and Saskatchewan being quarantined, an H5N2 avian flu outbreak at a turkey breeding operation north of Winnipeg, and several outbreaks of porcine epidemic diarrhea virus. So I've provided you a brief to complement my presentation tonight, and that brief sets this out in a little more detail. So I'll leave that to committee members to review. But what I really want to say is that taking photographs or videos of animals in a transport truck does not pose a biosecurity risk. Peaceful protesters do not pose a risk to animals or food safety. The second main concern that I have is that sections 13.1 sub 3 and 13.2 sub 2 would make it an offense to give a farmed animal food or water. This is completely unnecessary. This is not a pressing issue. There are no groups of animal rights activists running around Manitoba looking for farmed animals to give food and water to. We're in the midst of a pandemic, and I struggle to understand why prohibiting giving food and water to animals is a priority at this or frankly any other time. Second, in the extremely rare instance where an individual does give a farmed animal food or water, they are not harming the animal, particularly when an animal is exhibiting signs of thirst, malnourishment, or heat exhaustion. Giving the animal food or water would in fact alleviate their suffering, and it should not be an offense. You've already heard that on rare occasions when individuals give an animal, such as a thirsty pig in a hot transport truck, when they give those animals water, those animals have nonetheless entered the food system and been slaughtered. So no harm has actually been caused to the food system either. Now, I expect some supporters of the bill may say it's necessary to make it an offense because, who knows what a person is really giving an animal, but this is not a convincing argument. It is already illegal to give a farmed animal a poisonous or injurious substance. If an individual were to do so, they would be violating the Animal Care Act and also the Criminal Code of Canada. Finally, the offense is plainly illogical and I would say excessively punitive. If Bill 62 is passed as is, it will result in severe penalties and even imprisonment for acts of compassion. It would mean that an individual in Manitoba who has a pig, either a pet or one they're raising for meat, if such an individual fails to provide the animal with adequate food and water, they leave the animal exposed to the elements, or even if they violently abuse that animal, they could go to jail for a maximum of 6 months, in addition to some $10,000 in fines. In contrast, a concerned citizen who gave that very same animal food or water could go to jail for up to a year, in addition to, again, $10,000 in fines. And I say to you that this is plainly unjust and illogical. So in conclusion, without significant amendment, Bill 62 would violate animal protection advocates' rights to expression and peaceful protest, as you've already heard. It will make it harder to document and expose the suffering of animals in transport, keeping consumers in the dark about where their food comes from, and silencing animal protection advocates under the guise of biosecurity. Regardless of one's views on the ethics of industrial animal agriculture, this should be deeply concerning to all Manitobans. In a free and democratic society, we have the right to engage in public debate and discussion on important issues like food safety. Thank you very much again for the opportunity. I look forward to answering your questions.
Thank you for your presentation, Ms. Mitchell. Do members of the committee have questions for the presenter? The Honourable Mr. Peterson.
Thank you, Ms. Mitchell, excuse me, for your presentation. And I have your written submission here that I will review later.
Thank you very much.
The Honourable Mr. Brar.
No questions. Just
no questions.
Say thank you.
Are there any other? The Honourable Mr. Gerard.
Yeah, my question is this. Earlier on, there was a question of whether photographing or videoing an animal would be considered interacting. I mean, at the least, one presumes that you should have a definition of interaction that would exclude photoing or videoing.
Yes, I think
Ms. Mitchell?
My apologies. Yes, I agree with you, but I would say that it would need to go much further than that because the notion of interacting is so broad that, you know, we focus a lot on videotaping and photographing, and that's for good reason, but it would capture a much broader range of activity and potentially just create a chilling effect for any protests that happen, even on public property, even without disrupting vehicles. But if they occur near those vehicles, it's really hard to say what activities could and could not be construed as interaction. Certainly individuals at vigils, they do speak to animals often, and they do so in order to show those animals compassion. Speaking to somebody is clearly interacting, and there is obviously clearly no biosecurity risk from that either. So I agree with you that certainly we would need to be clear that photographing and videotaping is not caught, but I would urge you to still reject any notion that it is an offense to interact with animals because, again, it captures such a broad range of really integral, truth-seeking, and political expression.
Thank you.
Are there any further questions for Ms. Mitchell? We thank you very much for your presentation, and we will now, we have received another written submission from Lynn Kavanaugh from World Animal Protection. Is it the will of the committee to include this in Hansard? Agreed. Agreed and so ordered. We will now move on to the next presenter for Bill number 62, Tracy Groenewegen. I will now call on Tracy Groenewegen and ask her if she could give me the proper pronunciation of her name. I will ask the moderator to invite them into the meeting. Please unmute yourself and turn your video on. Hi, Tracy. Before I acknowledge you, could you please give me the proper pronunciation for your last name?
Groenewegen.
Groenewegen?
Groenewegen.
Groenewegen. Thank you very much. You may proceed with your presentation.
Okay, thank you. Good evening. So my name is Tracy Groenewegen, and I'm speaking tonight to register my opposition to Bill 62 as both an animal advocate and a concerned citizen. So much of what I have to say echoes what has been said in the presentation so far. Nonetheless, I will go through with everything. So what I find most disturbing about Bill 62 are the provisions around interfering with a vehicle transporting a so-called commercial animal and interacting with animals in transport, including providing food and water. These provisions clearly target animal advocacy groups such as Manitoba Animal Save and other SAVE groups who hold vigils on public roads outside of slaughterhouses, bear witness to the suffering of farmed animals, and take photos and videos to document how animals are treated in the animal agriculture industry. And yes, sometimes provide water to thirsty animals on transport trucks where it is possible and safe to do so. Bill 62 is nothing less than an attack on the MO of these SAVE groups. Holding vigils, bearing witness, and offering farmed animals, perhaps the only moment of compassion they've had their whole lives before they're slaughtered, is a particular strategy of peaceful activism. And this bill essentially criminalizes this strategy. As such, it seems to me a pretty clear violation of our charter-protected rights to freedom of expression and peaceful assembly. And as I'm sure this committee is aware, and as we've heard a little bit tonight, Canadian legal experts have also sounded the alarm over this bill and warned that it may very well be unconstitutional. Bill 62 is not an isolated legislative incident. It's part of a larger phenomenon, as we've heard tonight, known as ag-gag laws. Such laws are designed to make it illegal for concerned citizens to document and expose conditions on farms, in slaughterhouses, and on animal transport trucks. Ag-gag laws originated in the US at the request of the agriculture industry in response to images of suffering animals making it on the nightly news. Now ag-gag laws have made their way to Canada and have been passed in PEI, Alberta, Ontario, and now a federal bill, Bill C-205, is currently being considered as well. The wording of Bill 62 is virtually identical to parts of Ontario's recently enacted ag-gag law, which has been widely criticized as unconstitutional, as we've heard, and is currently being challenged in court. Such a challenge is not unprecedented. In at least 6 US states, ag-gag laws have been struck down as unconstitutional. Even in Manitoba, Bill 62 appears to be part of a larger trend toward curtailing peaceful protest. It is complemented by Bill 63 and 57, bills which similarly privilege the interests of private corporations, industry groups, and private property owners at the expense of citizens' basic constitutional rights. And as I'm sure the committee is aware, the charter states that the rights and freedoms set out in it are, quote, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society, end quote. In other words, restricting our charter protected rights must be warranted by some real issue of pressing concern. And in enacting legislation which limits our rights, the onus is on the government to demonstrate why such legislation is justified. The Manitoba government claims that Bill 62 is intended to protect biosecurity, but has brought no evidence to bear to back up this claim. In a Winnipeg Free Press article dated March 11th, Agriculture Minister Blaine Peterson is reported to have said that trying to provide water to animals being transported poses food safety risks. The minister is then quoted as saying, quote, are they contaminating that water, which would contaminate that hog, which would contaminate the food system? Notice that he phrased it as a question rather than a fact based on evidence. I can't imagine this passes any reasonable litmus test of demonstrable justification. And in fact, I have it on good authority, as we've heard tonight, that there has never been a single documented case of a biosecurity or food safety risk created by someone giving water to animals or photo documenting them inside transport trucks. And as a participant at some of these vigils, I can attest that the people who do this kind of advocacy work are among the kindest, most caring people I've ever met, who believe strongly in the rights and welfare of animals, as well as in various other social causes, and are not out to poison animals or the food system. At any rate, it's already a criminal offense to give a poisonous or injurious substance to an animal, so Bill 62 adds no value in this regard. In light of the lack of evidence of biosecurity risk and the fact that the Animal Care Act as well as the Criminal Code already address poisoning animals, it's clear that the true motivation behind Bill 62 is to keep animal advocates away from biosecurity areas and transport trucks so that they can't take photos or videos and publicize what goes on in the animal agriculture industry. As we've heard, the terms interfere and interact are incredibly vague, and I suspect this is deliberate so as to deter concerned citizens from getting anywhere near those trucks. Not only does this violate our rights to freedom of expression and peaceful assembly, it serves to reduce transparency even further in an industry that's already so hidden from public view and has so little government oversight. Animal welfare on farms is not regulated by the province or the federal government. Rather, the farming industry essentially creates its own guidelines for treatment of animals on farms, and these guidelines allow for considerable animal cruelty, such as the maceration of live chicks. The only legal protections for farmed animals apply to transport and slaughter, and these two are grossly inadequate. In fact, the maximum prison term for a first-time offender convicted of animal abuse under the Animal Care Act is just 6 months, half the maximum term for providing water to a farmed animal without consent under Bill 62. In the context of weak protections and lack of oversight, animal advocates play an important role in holding the animal agriculture industry accountable, or otherwise there would be no real accountability. Footage captured by concerned citizens in Manitoba, including those taking part in vigils organized by Manitoba Animal Save and other save groups, has shown, for example, pigs overcrowded in trucks, heat exhausted and thirsty and in clear distress. I myself have witnessed pigs foaming at the mouth on a truck outside the Maple Leaf Slaughterhouse in Brandon. Photos and videos taken of animals on transport trucks are not just fodder for animal advocacy efforts on social media. They're used to back up complaints made by these groups to the Canadian Food Inspection Agency. Bill 62 blatantly targets a particular approach to animal advocacy that aims to shed light on a brutal industry, and it sets out penalties that are extreme. The chilling effect it will have on this kind of advocacy work will only serve to keep the maltreatment of farmed animals even more hidden than it already is. This is a step in the wrong direction when more than ever people are thinking about their food and consumer choices from an ethical perspective and are craving more transparency and information to help them make decisions they can feel good about. We live in a free and democratic society. We should be directing our legislative efforts towards strengthening protections for animals and increasing transparency rather than criminalizing those who work to expose animal suffering in an effort to make positive change. Bill 62 is insidious at best. If it passes in its current form, it may very well be the next ag gag bill in Canada to be challenged in court. I ask that the committee strongly consider at least amending this bill, such as by removing the prohibition on interacting with animals in transport. That's all. Thank you.
Thank you for your presentation. Do members of the committee have questions for the presenter? The Honourable Mr. Peterson.
Thank you, Tracy, for your presentation. And Mr. Chairman, I have no questions.
The Honourable Mr. Brar.
Tracy, thank you so much for your presentation. Just wondering, what would you want changed in this legislation or removed at all from this legislation as per your experience and research studying this one?
Ms. Groenewegen?
Well, as I've said, I think at the very least, the provisions around interfering and interacting with animals in transport should be removed. Or like others have said tonight, they have to be a lot more clearly defined so that people have an understanding of what exactly is not being allowed. We know when we talk about interacting and interfering, because right now, those terms are so broad that that's where that chilling effect really comes in, because people don't want to, get anywhere near those trucks, for fear of finding out they've interacted with an animal and now, are facing a $10,000 fine or up to a year in jail. So as I've said, the whole bill is quite frankly alarming. Like the biosecurity zone piece, it leaves the door open for further stipulation of what constitutes a zone, potentially even public property outside of slaughterhouses. That would be very, very problematic. But yeah, as I said, at the very least, we're moving those two provisions. I think 13.2 in brackets 1 and 13.22, I think should be removed, if not extremely tightened up and based on real evidence.
The Honorable Mr. Gerard.
Yes, thank you, Tracy. You mentioned in the United States that a number of laws have been thrown out. Have they thrown out, for example, provisions which have forbade people from photographing or videoing animals?
Ms. Groenewegen?
I don't have an answer to that. I'm not a lawyer or a legal expert. Yeah, that would have been a question probably for our preceding speakers.
Okay, thank you.
Do any committee members have any further questions? Seeing no further questions, we thank you for your presentation, and we will now move on to the next presenter. There is a request to allow Jessica Scott-Reid to present next. She is number 21 on the list, and she has a preschooler. What is the will of the committee? Is it the will of the committee to allow her to present now? Agreed and so ordered. We will now call on Jessica Scott-Reid, private citizen, and ask the moderator to invite them into the meeting. Please unmute yourself and turn your video on. Thank you, Jessica. You may proceed with your presentation.
Thank you. My name is Jessica Scott-Reid. I am a Winnipeg-based and activist. I have been covering animal rights and welfare, food, and environmental topics for over 5 years. I am a regular contributor to the Winnipeg Free Press, the Toronto Star, the Globe and Mail, and others. My work has and does rely heavily on the work of activists, those who are compelled to be present in spaces where animals are often hidden and suffering. The evidence, footage, perspectives, and experiences gained by these activists have aided in the creation of dozens of my published works. Work that has been read by millions, work being done by few, if any, other journalists in this country. Bill 62, like other ag laws in Canada, will hinder my ability to continue this necessary work. It will hinder my freedom of expression and freedom of the press. For this presentation, I will offer an example of my work on this topic, an op-ed published in the Winnipeg Free Press, March 25th, 2021, entitled, Ag Laws Impede Important Work. In Canada, there is no outside temperature above or below which animals cannot be trucked off to slaughter. Regardless of Manitoba's extreme weather, nearly every day in this province, open-sided trucks without mechanical climate control haul animals to their death. For pigs, that trip can legally run for 28 hours without food, water, or rest. For cows, that maximum is 36 hours. And for newly hatched birds, 72 hours. Animal advocates have long deemed Canada's animal transport regulations the worst in the Western world. It is due in part to this that activists across the country have zeroed in on transport trucks as a place of peaceful protest and evidence gathering. But that may soon come to an end in Manitoba, thanks to recently tabled Bill 62, the Animal Diseases Amendment Act, and Bill 57, the Protection of Critical Infrastructure Act, which many legal experts are calling ag-gag legislation. Ag-gag laws are harmful to animals, harmful to the rights of protesters, and harmful to the rights of journalists like me. Animal agriculture is ubiquitously shrouded in secrecy. While knowing how the sausage is made may turn off consumers, a growing number of Canadians have in recent years become interested in the origins and ethics of their food. Getting a true glimpse of how animals are treated on Canadian farms, however, is difficult. In fact, outside of often deceptive industry marketing, it is only while they're on transport trucks or through footage gained by activists willing to be there that the public ever gets a chance to see animals. Dana Tong is a co-organizer with Manitoba Animal Save and Winnipeg Chicken Save, groups that hold vigils outside of trucks and slaughterhouses to document the conditions of the animals and occasionally offer water to animals in dire need. She says it is crucial that animal save groups, which exist all over the world, are able to be outside of these trucks in order to show the public how farmed animals are truly treated. Quote, "The CFIA isn't going to put images out there of these animals being transported. The meat industry isn't going to show what's really going on," she says. Quote, "And if we can't be there getting footage, showing what's going on, interacting somewhat with these animals, then there's nobody who is." In the past, Tong says she has filed complaints with the CFIA about animals on trucks appearing to have frostbite or suffering from heat stroke. Quote, "Then you never hear back from them. Or they send you a stock email saying everything seems fine," unquote. Having the ability to share directly with the public and media evidence of animals suffering in transport is necessary for transparency and accountability. Consumers deserve to know. I have written on the topic of farmed animal transport in Canada for numerous publications, thanks in great part to the shocking evidence gathered by activists from animal save groups. But if Bill 62 and Bill 57 pass, this will all become much more difficult. Activists could face significant fines or even jail time. Quote, "Law professors and legal experts across Canada have already warned that making it an offense to, quote, interact with farm animals en route to slaughter